Welcome to the InfoMullet YouTube channel. If you enjoy this content, please like or share. And if you'd like to support the InfoMullet by becoming a mulleteer, visit us on Patreon. We appreciate your support. There were two things that people had a lot of concern over, and I want to be, they wanted legal analysis and constitutional analysis. The two acts were his designation of Antifa as a domestic terror organization, and the second was the invocation of the Insurrection Act on Monday. So first of all, I want to be clear. When I do legal and constitutional analysis, that's not to say that this is the end all and be all. I recognize very, very well that there is a legal framework in which these can be discussed, and then there's an extra legal framework where these can be discussed. And simply the president making that statement sends signaling out to law enforcement agencies and Justice Department officials and all that. So there's definitely a consequence just by uttering those words. But the legal analysis is still important. The reason why is the president himself does not prosecute these crimes. He doesn't sit on the courts. This is why we have distributed court systems with a nomination process of appellate judges and district judges, which hopefully spans multiple administrations, is that the mechanism by which something like a domestic terror group is prosecuted under the law is distributed against not just Trump appointees, but appointees across many administrations using a common body of law. So let's get some context first. A couple years ago, with the mass shootings in North Carolina with Dylan Roof last summer, well, a year ago, basically, in Walmart with El Paso shooting and others, there was a question of why these, why, say, accelerationists, neo-Nazi, white supremacy groups, the Charlottesville Unite the Right riot, why aren't these declared domestic terror groups? And that was a big point of consternation on the left. Why are we not calling them domestic terror groups or terror groups like we would ISIS or Al-Qaeda? Well, in US law, there is no law or statutory authority to declare a domestic terror group. There's a clear one for foreign terrorist groups that, you know, if you cross transnational borders, there's a whole laundry list. I've got the statute in there. But the US does not historically, well, I shouldn't say historically, in the last 30 years, the US does not designate on an official list a domestic terror group. The FBI, if you look closely at the FBI, they have a list of concerns and they'll identify it by ideology. So they might say white supremacy is an ideology, but they won't name a specific group. Or on the left side, they may say we have concerns about certain ideologies, but we're not name some. They also have individuals, most wanted suspects. And the reason they do this is because in the United States, many amendments would run afoul if we designated a domestic terror group and tried to prosecute it the same way as a foreign terrorist organization. And this really is, I think, well illustrated with what's called the material support charges. If you're a designated foreign terrorist organization or there's a designated foreign terrorist organization like ISIS or Al-Qaeda, they talk to anyone in the United States. They get money from anyone in the United States, donations. They get material support. And I'm not talking just bombs and things like that, but blankets. You can be prosecuted under federal law for material support of a foreign terrorist organization. And that's the most common charge that's made in what I would call the terrorism laws for US citizens supporting terrorism abroad. If you did that with a domestic terror group, you would run immediately afoul of First Amendment, Fourth Amendment, other protections, because in the United States, your freedom of speech is sort of the outer limits of it is, and this is a point of contention, but currently the law of the land and the precedence is your freedom of speech goes to supporting the concept of violence, even if you yourself are not imminently calling for violence. And this is codified in the Brandenburg v. Ohio case, which is a famous case where there was a KKK rally, and literally the guy stood up there and said, we need to go do violence. And the police arrested him, and it went up with the Supreme Court. And the Supreme Court said he didn't call for imminent violence of a specific act and nature, and therefore his speech was protected under First Amendment grounds. Now, everyone's going to say, well, that's terrible because it's just enshrining white supremacy. Keep in mind, everyone on Facebook right now saying we need a riot and we need a revolution would be prosecutable were it not for the Brandenburg v. Ohio. Right? The Brandenburg v. Ohio protects our First Amendment rights to have conversations where we're serious or not about things like revolution, because we're not imminent and we're not saying a specific act, and we're not endorsing a specific method. That means to be prosecuted currently under terrorism laws, you have to be proven to be in a conspiracy of a very few acts. That means you have to, it's not just you're talking to people, you're not just donating to groups, you're literally involved in a provable way in a conspiracy to commit a terrorist act, or were proven to have supported a terrorist act. And that limitation is why there's no way for the president currently to declare Antifa a domestic terror group. It's simply the law doesn't exist. Now, another problem is that Antifa is what's called leaderless resistance. Leaderless resistance is a phrase that comes out actually of the right-wing extremism in the 1980s, where they sort of diffused, especially in the 90s after Ruby Ridge and some other areas, they began diffusing their leadership structures. And then you saw with the proliferation of the internet and innovations that came from the Arab Spring, these leaderless resistance movements are basically opt-in. They have a name, they have an agenda, but they have no set leader, they have no set organization. So declaring Antifa a domestic terror group is kind of like declaring birdwatching a terror group. Now, there are groups that call themselves birdwatching groups, but birdwatching is also an activity, and it gives a really broad license to prosecute this, which is why there's no legal basis to do it. That doesn't mean the president doesn't have other levers he can pull. And I see some people already asking about this. So yeah, so Michael's asking about RICO. Let me go through some of these because I've investigated these in the past and I've actually checked them. There are different ways that the first one that gets brought up, very relevant to what's happening right now, is can the Department of Justice incitement of riot? Incitement of riot is very different in nature than what's considered protected speech. It's literally the opposite. If you think of the Brandenburg v. Ohio, it's where someone says, we need to do violence, but it's not specific. It's not at a point in a time and a place. Incitement of riot in federal law is literally at the moment of time. It's saying, you over there, pick up that rock and throw it with that guy over there, right? It's a little directed action or something which is considered recklessly negligent, which would result in a riot. And you can do this either as a proactive charge where there was no riot, but you arrested someone on incitement of riot, or as a charge if a riot occurred. The trick is, much like conspiracy, you have to prove to a very high standard that the person you are arresting took the actions that were necessary to incite the actual riot. This came out of a Black Lives Matter protest. There's currently a court case wending its way probably up to the Supreme Court, where an organizer of a protest was charged with incitement of riot because someone in the protest threw a rock at the police or threw something at the police. That case is controversial because by law and precedent, that organizer of the protest should not be liable to that action because he did not direct that to happen. There was someone in a crowd. No one's really sure who. They don't have the person in custody. So they're charging the organizer. And, spoiler alert, he's black. So, there you go. But the incitement of riot usually has to prove a very causal relationship that you did the things which caused other people to commit violence. And so you could target, let's call it Antifa individuals, but you would have to prove this person here did that thing which directly caused the consequence of the actions therefore. Or this person, a riot happened and we went back on video and saw this was the person lighting the fires. You would have to prove that. You couldn't do a blanket sweep. And very importantly, incitement of riot doesn't extend to things like donations. You can make donations to your local birdwatching group that happens to be called Birdwatching Atlanta, and you can make donations to your local Antifa group through material means. Even if it's not going to be on PayPal, you can give them something. You are not prosecutable with that if they get hit with an incitement of riot. If we treated it like a domestic terror group under material support charges, you could be charged. Michael asked about RICO Act. The RICO Act is even harder to use to sort of prosecute a domestic terror group. And that's because there's three main requirements. You really only have 36 listed crimes that you have to be engaged in for RICO. It's not broad. It's like, it's murder, arson, kidnapping. Okay, maybe you can get that in a riot, maybe, or Antifa action. But then you got bribery, prostitution, and gambling. So unless Antifa's got like a casino with a brothel on the side running, most of the crimes in the RICO statute are not going to help prosecute, as a domestic terror group. Plus, even worse, the RICO statute is the individuals have to be in an association of some kind of legal or formal kind. This is where leaderless resistant groups are not in much threat of RICO statutes. RICOs are designed for things like the mafia, organized crime, corrupt unions, corporations that are acting in nefarious ways by design as opposed to byproduct, or benign neglect, or we can go on that later. And they have to have a pattern of criminality of 2 or more acts. So if you think about it, if you're trying to prosecute Antifa under a RICO statute, you'd have to find that these individuals engage in the specific crimes through a formal organization on 2 or more riots. And that's not very effective because the group itself, leaderless resistance, is constantly dynamic, it's informal, it's fluid. So I don't think you're going to see a lot of RICO prosecutions come out of this. The only question, the final thing that a lot of people ask is there's a lawsuit coming out of the Charlottesville Unite the Right rally where there was vehicular manslaughter terrorism or vehicular terrorism by one actor. There was a lot of violence and by other actors, and there was a lawsuit, which is technically, a lot of people are saying, well, that's, you know, these people are acting like terrorists. They're under a lawsuit. What law is that? Could the president use that? The Charlottesville lawsuit is under something called a deprivation of civil rights. That is a private suit brought where individuals say that person over there by act or deed or conspiracy took actions which led to the deprivation of my civil rights to engage in a constitutionally protected activity. It's designed for individual versus individual suits, which is what's happening in the Charlottesville suit. Is I think there's 17 individuals who are directly harmed by the riots there, or maybe there's 23, and they're suing 17 different groups and organizations that help sponsor the riots. The deprivation of civil rights is a useful tool for citizens to sort of police one another, but because if you've ever been involved in a large lawsuit, it's expensive, it's complicated, it's time consuming, it doesn't go quickly. This is not necessarily a law and order tool. This is a tool for civil lawsuits, and the punishments are fines. They're usually not jail time. And so those are the kinds of laws that we have around civil disturbances and things like that. Again, I'm not discounting that the president can simply claim to order, say, okay, Antifa is now on the list, now go arrest that guy over there because I think he's Antifa. May very well do that. We've had history in the past during the civil rights movement. You definitely had the FBI under the aegis of the FBI director investigating and monitoring civil rights groups. You've had abuses like that in the past. The purpose of these laws, however, is when those cases get to court, there's a hurdle to overcome of existing precedent and prior case law and the lack of a statute which authorizes these offenses. Again, I'm not saying that's going to prevent harassment, intimidation. So, I mean, even the chilling effect of the president saying this group is a domestic terror organization of any group is a potential First Amendment violation because you're talking about a political ideology that the president has just said this is out of bounds. Absent, we need to be clear here, any direct evidence. I know there's a lot of internet stuff going around about accelerationists and neo-Nazis and Antifa. I don't think there's as much of the agent provocateurs as there is just riots are complex. There's lots of people involved with different motivations, and they're not always on the same page. Gerald asks, what if are the police themselves inciting a riot by their actions? This is where, Gerald, good question. Unfortunately, the U.S. has a bias to protecting police departments. This is why I said when it comes to police departments, we're much more like the authoritarian states than we are a democracy and republic. We have a deference to the law enforcement. We have a tendency to protect them. And we've even put in place certain laws that make it very, very difficult to bring suits. First of all, federal law enforcement and National Guard, military type stuff, sovereign immunity. They're, as long as they're acting under the orders of the president, under the color of law, it's going to be hard. Local law enforcement, there's something called the public duty doctrine. The public duty doctrine means that because you owe a general duty to the general public for safety, you owe no specific individual a specific duty of safety. The police have no legal obligation to protect the person in front of them as long as they can claim they're trying to protect the city. It's very abstract and it's very hard to prosecute. This is why I don't want to get too deep into the public duty doctrine, but this is why I advocate the bottom-up reform of Campaign Zero and the top-down of DOJ investigation and consent decrees. And yeah, Ray brings up qualified immunity. Qualified immunity is a subset of the sovereign immunity. So the federal government has sovereign immunity, but qualified immunity means agents of state actors are also immune under any but the most egregious of circumstances. And that's a point for reform, but usually that's a state law. So finding and reforming qualified immunity would be a state-by-state action. There's not as much support for that as there might be, say, criminal justice reform or the campaign zero for like body cams and things like that. So I think if you were able to get qualified immunity change, that would at least allow police to be subject to more lawsuits and scrutiny on an individual level. But that's probably a tough hill to get to right now. So let's go from, but that wasn't the only thing the president said that was kind of dumb this week. So that the declaring on Antifa was Sunday's nonsense. Then on Monday, they clear the protesters of Lafayette. He walks out, he does this photo op that was kind of horrid, but I hope comes back to haunt him. Then he declared he was going to invoke the Insurrection Act. And this raised a lot of eyebrows because you cannot declare a group a domestic terror group. I mean, you can imply it, you can say it, you can hope people follow it, but there's no legal way to say that group's a domestic terror group and therefore the laws will come down. The Insurrection Act is different. So brief constitutional primer, not to go too deep. In the Constitution, posse comitatus prevents the military from conducting civilian law enforcement routines. There's a lot of complexity to this. I've included a lawfare analysis in the sources. The military can conduct law enforcement activities as long as it's military in purpose. So this is why you have unified, military tribunals, things like that. They can enforce military law on military personnel, but they cannot be used except in very specific extreme circumstances to conduct civil authority. However, there is something called the Insurrection Act, and it was passed to allow in times of crisis, natural emergencies, national disasters, a governor may call in the National Guard and under the control of the governor, direct that National Guard to support the state. What if the National Guard of that state isn't enough, right? Valid question. The Insurrection Act was to say if the National Guard is not strong enough to put down a local insurrection or support a national emergency, the state governor can request the president to provide federal military help. And this is where it's an actual law. I've included the links to the law in the thing. This is where if the state governor, say Georgia, because I like to pick on Georgia, if Governor Kemp wants to say, gosh, President, we need federal military to help us in Georgia, the Insurrection Act is a way to do that. The president can respond by providing military troops, federal military troops to the governor of Georgia. There's a second part of the act, which is incredibly dangerous. And this is the part of the act where the president can send in the federal military without the consent of the governor. So this is tricky. So the first one is the governor says, we are having a crisis. Our National Guard is not enough, or there's local resistance. I need help. I can't trust the National Guard. You saw this during desegregation, right? So Kennedy sent in, I think Arkansas, Louisiana, Mississippi, he sent in federal troops to help enforce desegregation laws for schools. That request is worked out. But there's a second part of the act, which I don't think has ever been used, which is where the president themselves say the disorder in the state is such an extent that the Equal Protection Clause of the Constitution is no longer functional. The state government's not able to be a state government and protect the people under the Equal Protection Clause. Therefore, that act authorizes the president to send in federal troops to establish the control necessary to reassert constitutional equal rights. Now, you can see circumstances where this might be valid. Under Reconstruction, where the Union occupied formerly Confederate states, and you had effectively an insurgency, what called the Great Revival, not really great or revival, but an insurgency of Confederate troops and sort of local resistance to the Union occupation. That's one example where you can say, well, there's, if we just remove the troops, there will be no equal protection under the Constitution in this amendment we just passed a couple months ago. That's one circumstance. You could see it if there was really widespread systemic corruption to the point that you can't trust the state to function in a law and order way. But that's not what's happening with the riots. The riots are very locally contained. They're in certain cities, in certain neighborhoods, in certain blocks. They look terrible because they're all on our media screen, and they are terrible if you're in those areas. There's definitely destruction, there's loss of property, but I don't know of anyone calling for the president to send in federal troops because my store got burned down. I mean, and I don't think you could say that one shop owner gets to make the call for the entire state for the president to override the governor's discretion. And this is kind of what the president seemed to be implying. I don't know if he thought it through all the way, but he seemed to be implying that if the governors didn't get tough, he was going to send in federal troops into the state over the objections of the governor to reestablish law and order. So this is a really bad idea on a number of levels. It's effectively a coup by the federal government over the state power. And again, you can argue legally whether the president is right or wrong depending on the circumstance. I don't think there's a very strong argument here at all that there is that kind of case. Under no precedent have similar circumstances and situations we've dealt with in the past justified the use of this act. It'd be an extreme overreach. Now, people are like, well, how do I know if it's happened, right? Trump is famous for blustering things and then kind of forgetting about it and wandering off and getting distracted by a parade or something. So how do we know if this is to happen? Well, there are certain things that have to be done before the federal troops can be used in this way. And by the way, I wanted to clarify, I did a little bit of spot checking this morning. As far as I can tell, there's probably only 250 federal troops deployed in a non-law enforcement way, at least acknowledged by the Department of Defense. We can probably, let's triple that and say there's 1,000. Most of the military groups you're seeing are the National Guard, not the active duty Army. So a little bit of a distinction there in semantic. But if the president wanted to send in the Marines, or he wanted to send in Air Force drones or something like that, legally at least, he would first have to issue something called a proclamation to disperse. This is an announcement that says, rebels, get thee to the hills, right? You know, the rebels or insurrectionists are the ones who are conducting this rebellion. You have a reasonable time for which you are to disperse and stop creating disorder. Call it 7 days, right? Once he has issued a proclamation to disperse, and if there is no disbursement, the rebels, so to speak, or the rioters in this place continue, the president appears to have at least the legal authority from a statute standpoint to do this very thing. As a radical moderate, I don't think he has a constitutional authority. I think that's a whole different ball of wax. But and it does imply a really serious breach. It would probably sacrifice the legitimacy of the federal government in a heartbeat. And I'm not saying the Trump administration, I'm saying the federal government, because now you would be asking potentially up to 2 million federal military troops to make a choice, make a call. The states would be resisting. There is no governor. When this came up for debate in an amendment, I think in 2007, 2008, every state governor from all 50 states, Republican and Democrats, objected to this power. So thanks for watching the video. Hope you enjoyed it. If you'd like to follow the InfoMullet, visit us on Facebook or Twitter. And if you'd like notifications when we post new video content, click on the red subscribe button below the video. If you've ever wanted to become a mulleteer and support the InfoMullet, visit us on Patreon. We appreciate the support.